Hi, I'm Terri Murphy for the Data Advocate here with our colleagues John Reilly and Saul Klein, doing an April update on what's going on in the real estate industry. And as we all know, there's been a disruption. There's news every minute about what's changing in the industry. And I'd like to start out with Saul to tell us what's going on with MLS and the DOJ.
Well, it's really the civil cases and the NAR settlement. And of course, the DOJ is in the background, and there's a piece, and John can talk about the DOJ piece, but there's about 4 or 5 pieces that all are coming together. And the big news, which took place on the Ides of March, on March 15th, about a month ago, was the National Association of Realtors proposing a settlement in the civil class action litigation, of which there are a number of lawsuits. The big one is Maryland, Illinois, Sitzer-Burnett in Missouri, where we actually got a judgment, and then the MLS PIN no select case in New England, where there actually was a settlement, and the DOJ stepped in and filed a statement of interest. And then, of course, CMLS, the Council of MLSs, filed an amicus brief, a friend of the court, in that New England proposed settlement, and Northwest MLS also filed in that as well. And then we had some issues with something that took place around 2019 with the Department of Justice supposedly settling with NAR, the National Association of Realtors, on some proposed or possible antitrust violations. And then the Department of Justice wanted to back out of that, and NAR didn't want to allow that, and the court didn't allow that. And then the Department of Justice appealed, and now the Department of Justice won at that level. And now they're unleashed again to look at NAR and to look at any anti-competitive actions there. But again, the big news started with that Sitzer-Burnett $5 billion, actually $1.83 billion judgment, and then tripled to $5 billion. That's billion with a B. And then the National Association of Realtors on March 15th coming up with a settlement. And the settlement, in addition to $418 million to go into a settlement fund from NAR, some practice changes in the industry. And those are the big things that's shaken up the MLS world. And of course, our perspective on that is nothing should shake you up. You should be looking at ways to kind of make things work better based on decisions that we're seeing. But if you look at that proposed settlement, there's a couple of big issues there. One is multiple listing services will no longer be an offer of compensation. So a cornerstone of MLS, at least a cornerstone since around 1993, when MLS changed from a unilateral offer of subagency to an offer of compensation, that will no longer be part of the MLS. However, sellers and agents of sellers will still be allowed to offer compensation to buyer agents. But that's shaken people up a little bit. The fact that the MLS will no longer be an offer of compensation, and the CBB fields, compensation to buyer brokers, that's going to disappear from the MLS. And then another piece of that proposed settlement practice changes is that real estate licensees will not be allowed to show property to buyers without a signed written contract. And that signed written contract must stipulate how and how much the buyer's agent is going to be paid for working with a buyer. And those are the big things out there. Now, we've seen every day. You're right, Terri. Every day we see something new, a little bit new. We saw something yesterday from Fannie and Freddie, because one of the issues that people were worried about is if a buyer has to pay the compensation to their agent, number one, where are they going to get the money? And number two, will it be possible to finance that, as typically we see today, where the transaction creates the compensation for both the buyer's agent and the listing agent? And will that be allowed to be practiced moving into the future? And there was some question about that, but it seems like that's starting to clear up a little bit with a letter from Fannie and Freddie yesterday. So that's news from the MLS world. John, you got anything you want to add to that?
Well, I'm glad you mentioned the NAR settlement, because the proposed one, because that is on everybody's mind, because they set up a series of practice changes for the industry that NAR and the plaintiffs' attorneys felt would maybe be an answer to some of the issues that led to lawsuits. The point, though, that I was struck with was the fact that the Department of Justice and other governmental agencies were not part of that NAR settlement. That's just a private settlement. So that leaves the question of what is the attitude or position of the DOJ as to the real estate industry itself. That's one that we've explored and are continuing to explore to find out what is really on the mind of the DOJ. What are the main things that they're hoping will happen? And if it doesn't come into play with the private lawsuit, will the DOJ pursue it further with their own agents who will investigate it? And they actually, as part of another lawsuit in the Washington, D.C. area, court upheld what they called the CIDs, civil investigative demands. And these are a series of demands that the NAR has to respond to. It's like an administrative subpoena. And there's a lot of pressure because it's very demanding. In fact, I think it's much more demanding than if anybody went through a IRS tax audit. You know how that'll really shake you up if you have to go through it. Well, this is going to shake up NAR. NAR tried to argue that in the earlier settlement that you were talking about, Saul, that there was a admission by NAR that in essence they weren't going to continue to investigate the clear cooperation policy and other things, and that they wouldn't go pursuing it with this CID, the subpoenas. Well, that was reversed by a DC Circuit Court. So now the NAR has to respond. And I think that's going to give the governmental agencies that are in the wings here, the DOJ and others, some solid evidence of what is really going on that they might want to address with their own actions. So we're monitoring that issue and reporting on it in the Data Advocate as well, Terri.
I know you posted a soon to come out article about that, and it's quite comprehensive and it addresses those exact questions. So I would encourage you to go to thedataadvocate.com and get the full report from John. And when you talk about this, John, I'm sure I got it from you. It said it's the industry's fault when you put up at least 500,000 unserious people in the world to help people buy homes, then set up things so they never talk about their compensation or what their actual value is beyond opening doors and filling out forms. You create ignorance. Well, I just recently interviewed Brian Boero, and you know he's with 1000 Watt, and he is addressing the whole value proposition from agents and the tactical ways to address these issues, because at the end of the day, he says it's all about fear and not articulating value beyond activities. Do either of you have any comments on that?
Well, so it's always been that way. We've been saying for years, you need to, and everybody says it now, and that is that you have to differentiate yourself from the competition, and you need to be able to articulate your value proposition. And the question we tell people, and I've told people for decades now, that they have to ask is, why would you hire you? Why would you hire you to sell your real estate? And one of the things that I've used is I say real estate transaction has 5 phases. It has 5 phases. Locate, if you're working with, and actually just go pre-locate, it's educate. The first step in that real estate and buying a piece of real estate, really from an agent's perspective, and it should be from a consumer's perspective as well, is educate. And think about all the things you do to educate a buyer or educate a seller. Then the next step is locate. If you're working with a buyer, market if you're working with a seller. The next phase is negotiate. And then if you're successful in the negotiation, you end up in what we've referred to as escrow or the closing process, and I say administrate. And then the last one is you close the deal, you continue to communicate. So there are these 5 phases to a real estate transaction: educate, locate, negotiate, administrate, communicate. And what we say to agents then and brokers is go back and pull out your last 10 transactions and create a separate, I use a piece of paper, right? A separate piece of paper for each of those 5 areas. Educate, locate, negotiate, administrate, and communicate. And then go through your last 10 transactions and write down everything that you did. No matter how small you might think it is, write down everything, and you'll come up with an incredible list. We refer to it as a menu of services. And then you can begin to create story around that menu of services. And one of the biggest items that people seem to leave out, and there's a great opening to present this, is the whole concept of being a fiduciary and what it means to be a fiduciary. And to a buyer, what it means to have somebody representing your best interest. And as a seller, what it means to have somebody representing your best interest as a fiduciary. And so another thing that if you're working with the seller, it's very important now, because we know under the current proposed settlement, should the DOJ and everybody else go along with it, is to educate the seller that a buyer's agent will probably be asking for compensation from the seller. Expect that and be able to articulate why that's of great value to the seller to have a buyer represented, and how much liability and risk there can be to having an unrepresented buyer if you're the seller. And so there's lots of education and opportunity with this new proposed settlement. And it's where the rubber meets the road, right? Is out there on the street, listing and selling real estate. And we tell people, that while it looks like there's a lot of change, and there is, this is a paradigm shift. And when a paradigm shifts, everyone goes back to zero, and your past success guarantees nothing when a paradigm shifts. And all of that is true. The fact is, there's great opportunity here to begin to articulate that value proposition. And we're going to see new models pop up. That's the intent, more competition. But take advantage of the fact that everybody now is paying attention to real estate. People still want to buy houses. People still want to sell houses. Lenders still want to make loans. Fannie and Freddie still want to buy those loans. They still want to package those loans. They still want to create mortgage-backed securities and sell them to pension plans and capital investors. So none of that changes. But the way in which we go about practicing real estate will have some changes. And you know what? We've seen this happen. We've seen changes before. Nothing of this magnitude, probably, but where there's threat, there's opportunity. And so it's time to settle down, take advantage of what's there, read it. Again, the data advocate, we're trying to stay up with this. There's all these pieces. I mean, it's amazing. I look at my desk and every day, right, there's just more things to read and to pay attention to. But that's what we're doing. John and I often joke, we're now curators of information. Right.
Well, that's what the data advocate's all about. And one of the things that Brian stated as being one of the co-founders of 1000 Watt, which is, by the way, a branding and marketing company, was whoever has the strongest value proposition, framing, and messaging will prevail. The buyer agent value story isn't going to tell itself. It's on us. And finally, we have to articulate that. And he said, you don't have to hire us to find a home. Zillow can do that for you, but Zillow won't tell you what the boots on the ground knows that they don't. And so there's a huge need. I think agents need to have that mindset that there is a huge need for you to be expert and for you to be an expert communicator. And Saul, you just gave us the 5 steps. That is a terrific exercise. Go back, Go to your last 10 transactions, pull out a piece of paper and write down everything you do, and not an activity. Placing a sign is just part of it. It's what are you doing to create that fiduciary inside information that a client or customer wants to have. So,
another thing that Brian mentioned was he said there's a difference between the serious and the unserious agent. And he's pinpointing that. I love that description, because there are people that are saying that they're representing the buyer, but they're really just maybe showing them the property. They're not getting into any type of negotiation. And that's one thing I like about the NAR settlement. The word negotiation is everywhere. There has to be, and this is what the DOJ would like as well. They want to have negotiation between the seller and the listing agent. They want negotiation between the buyer, consumer, and the buyer's agent. And they want the buyer agent and the listing agent to also get part of the negotiation. So the word negotiation appears everywhere in the practice changes that are made. And I think that's going to be a wonderful addition to the new real estate professional.
Yeah, we've talked about this before, Saul. We talked about educate. You have got to be a master negotiator. In this country, there's very few of us that do an advancement on negotiation. So I think that's going to be a big part of the standards that are going to go forward in getting people ready to be professionals in the real estate business. Last comments from either one.
Well, John reminded me of what was that term, John? Those that are serious or
non-serious.
What was the
unserious and serious?
Serious and unserious. It reminds me of being moderately committed and totally committed. That we used to use moderately committed and totally committed. So, bacon and eggs. The chicken is moderately committed, but the pig is totally committed.
Well, you used to have a quote from being totally committed that started way back when we had the internet crusade, and that wouldn't be bad to publish that again, boys. I think that's a great opportunity for us to understand the commitment here is serious. It's clearly serious now to the consumer. And one of the things that Brian talked about was skip the pontificators, join the doers. What are you going to do? And Saul, you gave us a great opportunity to do that. And John, you've outlined what we need to know. So I want everybody to join us on the Data Advocate for updates that happen every day from visionaries like Saul Klein and John Reilly. Thanks for joining us today for another segment of an update from the Data Advocate.